Lucasfilms just got slapped with a wrongful termination lawsuit by producer Catherine McCarthy in connection with the show The Acolyte, which was supposed to stream on Disney+. Catherine was hired as an executive producer. In reliance of this offer, she turned down a competing offer from Apple on the show Sugar, which would have made her the highest paid producer in the history of Apple TV. Apparently what happened was a deal was made with McCarthy's agent at UTA, David Morris, with emails going back and forth about the terms of the deal. The deal was accepted.
I will do what I must.
And McCarthy relied on that offer and progressed ahead in trying to find housing in Europe, knowing that this production would take place overseas. On April 7th, series showrunner Leslie Headland formally offered McCarthy the position to executive produce The Acolyte according to the complaint. The complaint was filed today on March 8th, so I haven't been able to get a copy of it yet. And what's interesting is most of the time in Hollywood, we don't actually get to see complaints because most things go through arbitration. But the clincher of this entire deal is there is no signed agreement because the only thing that's in writing for this offer are emails that went back and forth. And we will touch in a moment why some states have declared that emails constitute a formally accepted contract and that you don't need a signed contract for there to be an agreement between parties. On April 7th, the showrunner made the offer to McCarthy. She accepted. Lucasfilms assured her that the story arc of the show as well as the company's business plan called for The Acolyte to run for multiple seasons. After she accepted the offer, the studio followed up the same day with the series overview in the Season 1 Bible, which detailed the show's outline, character descriptions, and world. She immediately got to work as the complaint states. She began extensive research into European production, crew, vendor, and structure, writes her attorney, Robert Allen, in the suit. There was an offer, there was an acceptance, there was reliance, there was consideration because the terms of the deal. Here are the broad strokes of the deal. Candace Campos, vice president of physical productions at Lucasfilms, sent to McCarthy. She said that McCarthy would travel to London in June with a €2,500 living allowance and driver on top of a $10,000 tax advice allowance. We really want to make this work, Campos says. McCarthy relied on this offer and turned down the Apple offer. And in essence, she has lost millions of dollars of income, potentially, and a very high level credit on a Star Wars TV series that would have propelled her to the top of her career. She's been an executive producer on Ballers. After negotiating some more terms of the deal, on April 11th, McCarthy reconfirmed the deal with Lucasfilms, her acceptance of the offer, and officially commenced work according to the complaint. She was sent a written memorandum of the agreement memorializing its terms 3 days later. It provided that the effective date of the contract was April 11th and that she was an executive producer and it stated her salary, which was redacted from the complaint. She continued to work on the series until April 22nd when Lucasfilms terminated the contract. Notably, neither side signed the memorandum of agreement, though that doesn't mean her breach of contract claims aren't viable. Lucasfilms allegedly denied the existence of the agreement. The studio then offered to pay her $5,000, which she rejected. I think it's interesting that they offered to pay her anything because if there was no contract, why are they offering to pay her anything? McCarthy argues that Lucas's breach of contract will continue to damage her career and earning potential because it deprived her of future opportunities that would have flowed from being an executive producer on either series, The Acolyte with Star Wars or Sugar with Apple. At the time of plaintiff's acceptance of Lucasfilms' offer, defendants were aware that plaintiff had a competing offer from Apple that plaintiff would have to reject in order to accept Lucasfilms' offer, thus foregoing a valuable employment opportunity. It was a breach for defendants to cause plaintiffs to reject the Apple offer and make arrangements to move to Europe, only to be terminated before McCarthy had a chance to demonstrate her ability to satisfy the requirements of the job. So separately, right, they found this attorney, John Fowler, who represented Kevin Schulman in a breach of contract suit over a lost producer credit in Charlie Says that resulted in a $1.9 million verdict for his client, notes that it's not necessary that the parties enter into a formalized written contract for the agreement to be binding and enforceable.
Get ready to fight.
This is a handshake town. Damages in this particular lawsuit have the potential to be substantial given the unique opportunity relating to such a powerful franchise as Star Wars. What they are saying is completely true. As an attorney in Hollywood, I have left many a deal in email form, mainly because my executives didn't want us to move to a long form contract yet, because potentially they had some reservations or the project wasn't ready to go yet. Sometimes we will attach writers or producers or directors or actors and we do not have the entire film or TV show put together yet. So sometimes we will keep the offer or the deal in email form, but we can always come back and say, yes, it's a done deal. Or sometimes we will say, no, it wasn't a done deal. Now, a lot of courts, including those in Massachusetts and in New York, have held that emails constitute a binding contract if the elements of a contract are present. Is there an offer? Is there an acceptance? Is there consideration? Is there reliance? And are there damages? The plaintiff here, McCarthy, can really prove that there are damages here. Large studios like Lucasfilms, remember, they are owned by Disney. And I used to work at Disney, and I will tell you that Disney is very buttoned up, usually settle things. Remember Scarlett Johansson's lawsuit against Disney and Marvel for Black Widow? She claimed that she lost millions of dollars in box office bonuses, which could be in the hundreds of millions of dollars, because we all know how big Marvel films can be. And her film released in 2021 at the height of the pandemic, and Disney slapped back saying that she was being insensitive to the pandemic.
That's not my story.
And you know who else slapped back? Her agent, Brian Lord, who is the co-head of CAA, said that they are painting her in a way that is not her. When I make deals for actors, we always have a streaming buyout, because actors understand that they have their fixed compensation, they have their back end, which is their points, and then they have box office bonuses, which in some ways are incredibly important and could be the biggest chunk of their compensation, right? And because of the rise of Netflix and Amazon and Hulu and Apple and HBO Max, we now have to offer a streaming buyout. And that could be a flat fee of, like, let's say we'll give you $10 million for your fixed comp and another $10 million for the box office bonuses that you would have gotten had this film gone theatrically. So my point is this will probably get settled, because Lucasfilms and Disney will not want to go to trial. Because imagine, and I haven't seen this complaint, imagine if this complaint has punitive damages in there. Remember Johnny Depp and Amber Heard? You do not want this to go in front of a jury where they could potentially give punitive damages. You know, the common man does not like big bullies, and the big companies that try to take advantage of small actors, and I mean small, you know, I mean metaphorically, like a common person, like a producer here, like McCarthy, relied on this offer and turned down a very lucrative job with Apple in order to take this deal. So her claim that she has lost millions of dollars is probably accurate. I mean, the courts will have to look at the fact, but I think Lucasfilm will probably settle this because they do not want this to go in front of a jury. The exchange of emails amount to a binding agreement, and in this specific case, it was a agreement to settle. The trial court said no, but then the higher court reversed the decision. So this case means that pressing send on an email is now potentially equivalent to signing a piece of paper containing whatever statements appeared in the email. An actual typed signature is not necessary. If this goes to court, that's what the court will have to look at. Anything in the email that states this is not a binding agreement, I'm willing to bet that there isn't, because in Hollywood, when we're making deals, I've seen so many email chains that come my way from my creatives, from my executives, that don't ever say this is not a binding deal. I always have to say all rights reserved in my emails, and all rights reserved, oh my God, I pound this into my junior attorneys and assistants. Every email that negotiates a deal has to say all rights reserved, because if that's there, that means we get to reserve the right to make any changes, and that this isn't a binding offer or a binding deal. I'm Tyler, the Hollywood attorney. If you have found this video to be of value or you've learned something, please consider subscribing. It really does help my new channel. If you didn't catch my last video about yet another lawsuit between two studios whereby HBO Max is suing South Park and Paramount for basically double dipping and giving South Park content that should have gone to HBO Max to Paramount Plus instead for $500 million. Make sure to catch it there. This is Tyler. Remember, we are born perfect and we forget. I'll see you guys soon. Bye.